Thank you. Could you be more specific about consistent with medical need? Is that if the cancer patient needs greater amount, or will that be specified?
Exactly. Should a caregiver need to be able to dispense more than 2.5 ounces to these individuals to make sure that they have the appropriate amount of medicine or level of medicine to treat their conditions, the caregiver will be able to receive, the patient won't have to because we have the patient confidentiality, the caregiver will be able to receive that waiver from the department in order to serve that patient.
And then is the waiver for unlimited, or does it double it, or is it the department's discretion of how much more than 2.5 ounces?
It'll be consistent.
You're right.
It'll be consistent with the medical need. You may have some who need 3 ounces in a 15-day period. You may have folks who need 5 ounces in a 15-day period. It'll be consistent with medical needs.
Additional, Senator Haskell.
And the medical need as determined by
The qualifying physician. And however, whatever form of medication
right.
they are prepared for them.
I just wonder if it might be helpful in there to say medical need as determined by the qualifying physician.
Well, it may not be determined by the qualifying physician. It depends on what kind of form they're creating, they're using to dispense the medication. If you're using a tincture and the topical, I believe it takes a lot more, and I'm looking at Catherine Lewis here in the audience because she has a cancer patient that she uses a lot more for. To make the Rixixin oil, it takes a lot. More than certainly 15 ounces.
I get what the issue is.
Yeah.
I'm just trying to say, who's gonna make that determination? The caregiver?
I believe the caregiver would have to justify that to the department for the waiver.
And so, right, and so would there be rules regarding that waiver? And if there are, then that makes sense to me.
Yes.
Okay, thank you.
Any additional discussion on that particular piece? All right, seeing none, Representative Sanderson, please continue.
Okay. And also, we added in to make it consistent with the caregivers in the waiver. I asked Mike to put the very same waiver language in where the dispensaries are to make that consistent. Okay. Under section 13, it's where we changed to enforce municipal code instead of to further the business. The next page, at the top, again, the same. Section 15 is where it became very tricky with the wanting primary caregivers who are not required to register at this time because they care for a family member. So I added the language that they are required to register and pay fees except that, and we have these 4 exceptions now. The reasons that except that, fees will be waived for a registered primary caregiver designated to cultivate for up to 2 qualifying patients if those patients are a member of the household of that primary caregiver. I took the language that was struck below and added that back with fees waived. You can read through that. There's also the language under 2 that says they will be required to register with the Department of Health and Human Services by January 1, 2016. That may need to be in another section of law, I'm not sure, but because we were talking about that topic and pushing it out further, that's where I wanted that information for reference for the committee.
Yes, Representative Hammond.
Thank you. Deb, could you clarify, for somebody who's a caregiver for somebody in the same household currently, are they required to register?
Currently, they are not. However, some caregivers in the same household have developed an awful lot of cousins. So, and they must be a resident of the state.
Okay, so there's
If they're for a family member.
additional registration requirement that's not currently in place.
Yes, but the fees will be waived.
Fees waived.
Fees waived.
How much is that fee?
Right now, it's $240 per patient if you're a caregiver for somebody who is not a family member.
Okay, thanks, I just want to clarify.
Yeah.
Any,
This piece is also helpful for law enforcement. If you have somebody who files a complaint or makes a notification that they know somebody is growing marijuana, if they are now registered and law enforcement checks in with the department will be, or the Metro check, they will automatically be able to see that they are a caregiver and they'll leave them alone. Okay?
continuing along?
All right. In page 6, we added the language that was missing from previous statutes passed that says employees of a registered primary caregiver. Then in section 21, the department's amendment regarding child cards is added back into statute here. It was not in the bill. That was a separate amendment that the department brought forward. It was inadvertently repealed in the original bill language. On page 7, instead of the top paragraph, instead of acted in bad faith with respect to, we changed that to violated the law. In section 24(5), a highlighted area, registry identification cards expire, that language is to be repealed. That is no longer relevant to statute. Moving on to page 9, section 32. That language is a full repeal.
Yes, Representative Henderson.
Thank you. So just for clarification, but they do expire 1 year after the date of issuance. Is the information below it that crossed out?
Patients are no longer required to register, so that talks
Oh, I
about a
see.
patient registration card.
Okay,
Okay?
thank you.
You're welcome. So section 32, that is that will be amended to read that section 32 is repealed.
What does section 32 do? To Representative Henderson.
I guess it's not crossed out. It says registry identification cards expire 1 year after the date of issuance.
Yes, Michael.
So just to jump in, I think that Representative Sanderson struck that whole area there, and when I was sitting next to Mr. Albert, he had put a period in the middle of that sentence, and so I think that there may have been some, I could be mistaken about that, but I believe that there was just a little bit extra stricken out, so I just included that back in there, the portion that Mr. Albert had wanted to remain.
That's right.
Okay. So that's why that looks that way. I just
So everything in the gray box has a strikeout.
right, and then I just included the beginning of that first sentence again,
Okay.
and that so that the underlined portion should remain.
I thank you. Okay.
Thank you. I'm a beginner drafter. It was my first attempt. So section 32 is repealed, and we go on to section 33. Here's that third place where we put enforce municipal code instead of further the business of municipality. Under section 34, the revocation of a caregiver certification card. Section B it will read, a primary caregiver whose caregiver registration card has been revoked shall, in accordance with this chapter, dispose of all medical marijuana in any form, with the addition of the language for designated qualifying patients. And then for clarity, I added C, that says a primary caregiver whose caregiver registration card for qualifying patients has been revoked may continue to cultivate for themselves if they are a qualifying patient.
Oh, yes, Senator Haskell.
You can grow for yourself without registration. Is that correct?
Yes.
Then if you have as a caregiver, then had that revoked, had your registration card revoked, you still continue without a registration card, do we need to say that?
We can correct the language that needs to be corrected. However, for the registered, for the qualifying patients, your registration cards, you get an individual card for each one. Those will be revoked. However, the intent is not to prohibit someone who is a qualifying patient from growing for themselves.
Okay.
Okay? And that may need to be clarified.
No, I understand, and I'm just wondering if we even need it, but probably better to put it in twice than.
I put it in for clarity. Okay. Then, under section 36, 1A, the department shall promulgate routine technical rules consistent with the process for investigations to ensure compliance. Under 3, you'll see the changes where must has been crossed out and may is in there. And then also the language, each day a violation constitutes a separate offense. A person who at the time of violation of the provisions of this chapter has been previously found to have violated the chapter commits a Class D crime, that has been struck as well. And that is consistent in both 3 and 4. In section 5,
Yes, Representative Hyman.
So we've heard a lot about those fines. Is everyone comfortable with that amount of fine? Is that where we're landing on the fines? Where are we with that?
it's my understanding we're okay with 3 and 4 fines. It's language in 5 and 6 where there's maybe a little unnoticed.
I don't know, I'm just asking a question as we find.
Okay. All right, so we'll continue on, and if we want to come back to that, we can.
Under section 5, penalties for failure to register as a primary caregiver. This is where there was a lot of thought and angst because of the requiring of a family member who has not been required to register till now, for quite many years, since 1999, I believe, when we first had the law, is now going to be required. So the language has, at the end of the original language, I included, except that, A, a primary caregiver under section 15, this goes back to the language under the primary caregivers, will be exempt until January 1, 2016, and B, primary caregivers under section 15 after January 1, 2016 will be referred to the department to comply with this section. That's the crosswalk I felt was very important to go back to. Make sure that any family member who just didn't realize they were supposed to register, they had an opportunity to correct that. And then on the last page, burden of proof is struck on 9. And I added a new 9, compliance rules. And the department will create routine technical rules to develop technical assistance and a clear process of corrective action plans for findings in violation of the Maine Medical Use of Marijuana Act. That's where we are.
Discussion? Can we, we do have this list of concerns that was submitted by Hillary Lister. About 2 particular areas, would we like to discuss those areas?
I'm reading down through these. I believe a lot of the entries in here and the crosswalk back, the January 6th, they're referring back to the department in order for someone who hasn't registered to have the opportunity to register. I believe most of those have been addressed in here, and I certainly understand the concerns. I believe that addresses,
So I guess the one thing in here that I wonder about, and again, I'm just working my way through this, is so still an individual who is growing for themselves, isn't growing for a family member, isn't growing for anyone in their household, is growing for themselves, as they're legally able to do. They would still not be required to register. Is that right? Are they required?
No.
Right, they're not required to register.
are they going to be? Was that the intent? No.
Right.
Okay.
So I guess I wonder, with the concern on, so like, I guess the concern expressed here, an argument for this change is that it would allow law enforcement to know who is legally cultivating. Maine's law protects patient privacy and doesn't require a patient who is cultivating only for personal use to register. This could result in law enforcement taking action against legal patients, assuming you're cultivating illegally since their name doesn't show up on a registry. That's the argument made at. Would you like to? I guess any questions on that? I mean, I guess I do wonder about if we're concerned about someone, a neighbor saying, "Oh, my neighbor's growing marijuana. I'm concerned they're doing it illegally," and I guess that's one of the reasons why we want to have people growing for family members register, albeit with no fees. But are we? I guess for that person who's just growing for themselves, are we inadvertently making their situation worse by creating the expectation that everyone who's doing it legally is going to be registered?
I don't think so. I think the situation here is that the department has tried to extricate itself entirely from the physician-patient relationship here. There's no regulatory framework around cultivation other than that the patients are allowed, qualifying patients are allowed to cultivate for themselves. So while the gap is covered for law enforcement in large part by requiring all caregivers to register, remains a small gap for our patients, but that's a small issue.
Any Representative Burstein?
Yeah, I don't think it's creating a problem.
Okay. This is just the one concern raised. How about Representative Burstein?
I just have a couple of questions, and it's totally in a different part of this. One was under the summary in number 14 about the vets, that no slut. Oh.
Here, Representative Sanderson.
If I can answer that, that language is struck because there's no longer any, it just doesn't apply anymore. That summary's wrong.
The summary that in what was just passed out is
Yeah.
wrong.
Yeah.
Wait.
And there used to be a sliding scale for veterans to register as patients. There is no patient registry anymore. That language no longer applies.
Okay. So I've got a couple more questions, if it's okay.
Yes, Representative Burstein.
And then the next one, the name of the complainant who reports a violation of the act is confidential. So if I'm growing, someone starts complaining, I can never find out who that person is?
From the department's perspective, all of our licensing programs allow that. Otherwise, it has a significant chilling effect on an individual's willingness to come forward to the government to complain. We receive literally thousands of complaints per year of various programs. We have complaint intake units that process the complaints. We triage them, where we monitor them for the same person who's coming in. So we have frequent flyers, we call them, so we don't take action on those complaints. It is conceivable that somebody could complain about you, and that we would inquire about that, but if we don't have any findings, we move on.
Just one more. And my last one is there, I didn't see in here a course for like appeal or a process, so would you just on that where I might find it in here? Like if the complaint was brought against me, I think it was totally frivolous, how would I go about that? And I'm sure you must have some sort of step-by-step protocol for
We
that.
do, it's not part of the law that we're amending, but the Maine Medical Marijuana Act complies with and there are provisions in here, however, which do address that, because we're trying to enhance the appeal process, but it comports with the Maine, Administrative Procedures Act, thank you. The Maine Administrative Procedures Act, those appeal rights are consistent with what you're seeing here and with what's available.
Okay, thank you.
I have one question, back in section 15. So, I understand and appreciate where the department is seeking to go with the family piece. I guess I wonder, so part of the reason we don't have the patient registry, right, is patient registry is because patients, I think, understandably have concerns with the current federal status and how marijuana is treated on the federal level. They don't want it, in a database somewhere. But I guess I wonder if you have someone growing for a family, people in their household, and you're requiring the person to grow, who's growing for the household to register, are we, if the federal government were ever to take an interest, are we then creating a situation where the patients are kind of in that situation where they might not be registered, but their household is?
That same argument could be made for the patients of cultivators, of any cultivator in the state. So the database that we have is you don't register, we don't identify in the database that you're registered to cultivate for who it is. You're just registered to cultivate marijuana as a registered caregiver in the state of Maine. If you extend that logic of your argument, that would apply to all caregivers in the state, regardless of who they're cultivating for.
Well, I guess the thing is, if you're cultivating for someone in your household, then it's easy to figure out who's in the household. But if you're cultivating for people who aren't in your household, then that could be any number of the million and so people living in the state.
The government does not retain any information about who you're cultivating for. You're cultivating for one, two, you get a card. It says that authorizes you to cultivate for, each card represents one person. So there's no information about whether it's a family or whether it's a patient that lives two towns away.
Okay. I'll drop that for now, but Representative Hymanson?
Thank you. So just to fill in my holes here, is there any circumstance where someone could be growing plants in their household that doesn't have a cap on it, where they could be cultivating many more than, growing and having plants left over that they're selling? Is there any group that we've left out where they are left on their own and could potentially grow a lot?
No. There are caps on the amounts that can be grown for patients, caregivers, and for dispensaries,
Okay. All right.
which are the only groups that are allowed to cultivate marijuana.
Patients growing for their families?
Patients must cultivate for themselves.
Okay. For other people? Okay. I mean, that's the group I'm concerned about with conversion, so just want that answered, so I have some very concerned people in my district. And I want to be able to go back to them and tell them that we plug those loopholes and
I'm not saying that all people will be.
I understand.
But a patient can't cultivate for somebody else if they're only authorized to cultivate for themselves. Caregivers must cultivate for only up to 5 patients. So, I think that what this does is it creates a situation where every individual who's cultivating, other than qualifying patient, must register as they're cultivating marijuana in the state without getting a patient route.
Okay, all right, thank you.
Representative Burstein and Representative Hammond will be on deck.
I guess we're bouncing around a little bit with all these subjects, but my question is there any situation that there is a sliding scale fee for the fees? And I'm just thinking about someone who may be very poor, needing medical marijuana, but the caregiver still has to pay that certain fee. So is there any sliding fee on anything?
Representative Sanderson?
For the patients who, for the individuals who are looking for a caregiver to cultivate for them and they are lower income, there are many caregivers in this state who are now providing that for no compensation to the patient. And under current law, they are able to do that if no compensation is accepted.
So they don't have to pay that registration fee for that patient, is that correct? So that there's they can grow for free, but that caregiver doesn't have to pay that registration fee, is that correct? Okay. You think so?
So I would just clarify one point there. Every caregiver must register and pay the fee, but it's up to them to decide how much they want to charge that patient for marijuana. If they don't charge at all, so you can be charging up to 5 patients, but you can have a 6th, a 7th, and an 8th patient, let's say, the qualifying patient that just can't afford it, and they're allowed to give that patient marijuana for nothing in exchange, for no money in exchange.
But they're still paying that. They're not paying.
Only the person who's growing.
The cultivator caregiver.
If the cultivator's patients, if they're full, 5 slots, they
Right.
have to pay the fee for those 5 slots. However, if there is a 6th or 7th patient who cannot afford to pay, many of the caregivers are incredibly generous with these individuals and provide that medication to them for free. And they don't have to pay for that
Okay, that's
6th
the question.
or 7th because
Okay.
they're not necessarily, they're donating to someone who needs medication.
Thank
Representative Heinzen.
Thanks. So, and being in the state, you've got less than 24 consecutive hours. Who is going to monitor that and what circumstances? And, I mean, that's going to be a hotel room for a night, which is good for our local business, but I'm not sure what we're looking for here.
Yeah, that was a request made of the department by law enforcement, because there was no restriction on particularly in the concern came from your jurisdiction, and well, not only but the larger
The borders.
right, the borders, and we're not, it's going to be very challenging to enforce that. We're hoping that it's just some language that folks are aware of that, and if they get caught violating that, there will be ramifications for violating that. Enforcement will be challenging.
What would be the ramifications?
Depending on which state they get caught in. So if they're caught in Massachusetts or New Hampshire, or the ramifications will be on that end.
Not on this.
If they're a qualified patient, if they're a registered caregiver in this state, and something occurs outside the state, yes, we could take action to revoke their caregiver registration, but it would result, they would be violating this law, therefore they would be operating outside the confines of the Maine Medical Marijuana Act within the criminal realm.
So they have to
whatever.
be caught outside in their own state?
Correct.
And then it would come down. Okay, that's what I understood. Thank you.
Representative Hammond, then Representative Sanderson on deck.
Thank you. So hypothetically, so say I was a caregiver for somebody in my household, a family member in my household, let's say a child, and I register as a caregiver. I do not pay a fee for that patient, is that correct? So when I register, there's no fee for that patient?
That's correct.
Okay. How does the department know that that person is a member, that member of the household is a family member to waive that fee?
We would have to develop the proper forms for that, proper application forms for that. But the other piece of that that I also want to clarify is that if you're cultivating, you can be a caregiver for a patient and not have to register in the state, register with us, and that doesn't change. So if I can be a caregiver for my grandfather, and I can go to the dispensary, or I can go to another caregiver. I'm a non-cultivating caregiver. Can get the marijuana it allows me to legally transport that marijuana to my grandfather for his use. Or it allows me to legally administer that marijuana to my child, that medical marijuana. Only if you're a cultivating caregiver are we requiring that you would register in the state. So it's cultivation. And there would be either way, there's no fee.
Sure, and I guess, how does the department know? You said they don't.
Where we have to develop the application forms. We have to change the current application form to reflect that.
Okay, how do you see that being reflected on the form? Is it
And
Social
so
Security
I haven't given
number?
that thought.
Okay. Okay, I guess I'm concerned about adding people to the registry that aren't currently part of the registry, and I'm wondering what's the motivation for that, or what's the reason, what's that, what are you hoping to accomplish by adding that?
The biggest thing that I see from a policy perspective, that it aids law enforcement, so that if you are a registered cultivator and you are come into contact with law enforcement and there's an inquiry about that, they can check that automatically. Secondarily, there's just a policy perspective that if you're cultivating marijuana in the state, regardless of your situation, you should be registered. You should have to register with the state for that privilege of cultivating under the Medical Marijuana Act.
Okay, so it's consistency between the people cultivating for a family member versus cultivating for somebody outside the household. Okay, have you seen any issues with people cultivating for somebody in their family that might necessitate something like this?
Many. As Representative Sanderson said, the way the current law is written, as an example, we had literally a frat house. They were all under the same house. They were all living in the same house. They were cultivating for each other. We have very large extended families, so this tries to rein that in a little bit and tighten it. At least there's a requirement that you have to register, so you might be a little more thoughtful about being compliant with the laws and regulations around cultivation of marijuana under this act.
Additional discussion? Is there any additional discussion we want to do on this bill at all? Or would we like to corner caucus? Okay. We're gonna, corner caucus.
That was the clarification on that.
For themselves.
Patients are on the picture, that's long.
I guess that's cool. I guess one form of
I was all still on Saturday, so it's like a day away from me. Yeah.